Evening, Senator Bradley. Will you remark on the legislation?
Yes, I will. Thank you very much, Madam President, for giving me the opportunity to do that. And thank you very much, Senator Winfield, for all the hard work you've been doing. I really want to reach out to my brothers and sisters across the aisle, my Republican colleagues that I've been hearing now for several hours, our debate. I want to let you know where I come from in terms of this particular piece of legislation. I want to give you a small anecdote of a positive story that I've had with a police officer. When I was at a community college, I rear-ended a car. I thought nobody saw it. My father's blue-collar ethics kicked in and said, I can't just leave the scene. I got to leave a note letting this lady or person know that I hit the car. So I put a note saying, this is my name, my number. You can reach me here to fix the back of your car that I ran into as I was pulling out the parking lot. There was a police officer who saw that. I didn't know, and he recommended me for some citizen award thing, white police officer who saw that and recommended me for some citizen award thing, which gave me a little scholarship, which helped me take another course at the community college that I was attending, which inspired me to go further and pursue my education. And it was that act of kindness that officer did that allowed me to appreciate people, just people. You know, we get in the quagmire of black and white and brown and all these things in this circle, but I think that we forget oftentimes of the quality of police officers, state troopers, correctional officers that we have here in the state. And I'm not one of these people that wants anybody to feel bad for me for being a person of color. I've heard people on the liberal side of my caucus say things, can you imagine how horrible it is to be a person of color? I don't want a sympathy card. I don't want you to feel bad for me. America has not been a horrific experience for me in this country. It has blessed me with wonders. It has given me wonderful opportunities. Here I stand before you as a state senator, an urban kid from urban America, from humble beginnings. That's America. That's the American dream. So I don't agree with the liberal disposition of some members of my caucus who say things like, you know, can you imagine how horrible it is to wake up every day and have some melanin in your skin? And I don't believe in these things that other members who tell us who's black and who's brown and who's this and creates further division in our caucus. That's not my worldview. I come simply to talk about this piece of legislation from a standpoint not as a person of color, not as a minority, not as an urban legislator, not as a person who had some horrific experience with the police, but from a person who cares deeply about the state of Connecticut and from a person who loves this country more than myself. I love America more than I love myself. I want to see America prosper more than I want to see my own prosperity. And I want to talk specifically of how we got to this point. Let's talk about 1967 Person v. Ray. That's the first time the Supreme Court invented this notion of qualified immunity doctrine. Just to make it clear, there is no federal law that has qualified immunity doctrine. As a matter of fact, jurisprudence, people such as Antonin Scalia, those people here are attorneys, know the name, a great Catholic, a great jurist, may he rest in peace. He's recently passed away. He said that this is judicial activism. There's another jurist who talked about this, little-known jurist by the name of Clarence Thomas, a guy who we oftentimes don't agree on legal issues. And he says that the Supreme Court invented this legal doctrine and has little basis on written law. There is no basis in this in federal jurisdiction. There is nothing that says that this law exists and this is what happens. It was passed and invented in 1967. Now, I wondered, what in the heck was going on in 1967 that the Supreme Court of the United States found it incumbent upon themselves that they needed to come up out of full theory, bypassing the legislature, bypassing the executive office, and come up with this theory? Well, let's see what New York Times says was happening in 1967 that would inspire, by then I think it was all men who were sitting in the Supreme Court, to do such a thing. January 8th, Vietnam War. January 10th, a proclaimed segregationist by the name of Lester Maddox became the governor of the state of Georgia. February 18th, district attorney claims he solved the conspiracy of the assassination of JFK. April 14th, MLK denounces the Vietnam War. April 28th, Muhammad Ali refuses military service. May 2nd, Black Panther Party storms the California Capitol building. June 11th, race riots in Tampa Bay, Florida. June 12th, Loving v. Virginia. Great Supreme Court law that said that for the first time in the United States, black people and white people were allowed to be married. And it was unconstitutional to do anything else than that. June 26th, race riots in Buffalo. June 12th, race riots in Newark. That's puberty so keep getting. June 12th, race riots in Minneapolis. June 23rd, race riots in Detroit. July 3rd, race riots in Milwaukee. August 1st, race riots in Washington, D.C. October 16th, I don't know who this person is, but you probably know who he is. Some people here probably know who he is or her. Joanne Bays arrested for and beaten for blocking the entrance to a military induction service. That's what was going on in our nation when the Supreme Court decided to come up with this theory of qualified immunity. What's the problem with qualified immunity? Do we want, the word sounds so beautiful. If you're a cop, you don't want cops to go get sued for things that they did in a split-second decision. I agree with that. You shouldn't take someone's house and livelihood and pension and everything they worked for when they just made an honest-to-God mistake or a split-second decision. And maybe they were wrong in what they decided to do. I agree with that. But what's the issue specifically with qualified immunity, and why is it that jurists like, and who says it better than Puerto Rican women? I know best because now I got one at home, Ms. Sotomayor, who highlighted in a particular case that out of 200 cases, none of them were deemed worthy and were all dismissed because of qualified immunity. What's the problem with the doctrine? Let's look at the doctrine. The doctrine talks about clear, established law tests. That's the stuff that we've been talking about here that people don't understand what that means. So it's not enough for a plaintiff or a victim to say this officer did something to violate my rights. It's not enough. You have to show as a matter of law that there is case law that is extremely similar to the action of that police officer, and on the basis of that, that police officer should have known that his conduct was illegal. And if there is no case law that's extremely similar to the fact pattern of that individual, then that officer is off the hook under qualified immunity. Doesn't matter how egregious the conduct is. 200 cases and not a single one of them stood the test. That's a whole lot of cases, because that's a very difficult burden that you have to meet. Now, Senator, you've done a great job. And I'll hit on some things here that I hate and some things that I love. But it shows you the fairness of the process. And I said this in caucus, and there's no secret to you. It's 1 year we're giving people to be able to do this. 1 year. Anybody here who's ever practiced in criminal courts knows that for a simple AR application, which stands for accelerated rehabilitation, these are small offenses that people, bite of the apple, that you did some knucklehead thing, got into a bar fight, did whatever thing that was wrong. They allow you to apply for this program. That sometimes takes a year or longer to go through the system. Now, what if we're talking about somebody who's complaining about a false arrest? There is no way that you're going to get through the system in 1 year with something when you're talking about a police officer who violated somebody's civil rights, because there's an underlying arrest usually under those things. You don't just usually violate your rights and say, okay, now you can go home. They violate your rights, and usually you have a criminal charge to justify what they did. So you're only doing 1 year. And Gary, I fought back and forth with you, and I know it was compromised to get everybody on board, and we're trying to get everybody on board, and I commend you for trying to do that. I got a problem with that. I got to swallow that. Because as an attorney, as a person who defends people, I know it's going to be still difficult to be able to get this down the pike and make sure that we can rectify the things that are wrong in this country. Now let's talk about other issues here that we've been talking about, and I think that Senator Lesser did a good job of asking you these questions. When we're talking about this particular set of law, Senator, and it's in a question form just so that I know, and I can advocate better for my constituency, and there's some sort of a record here as to what we're talking about. What we're talking about here is getting rid of the clear established law test that was established by the Supreme Court. Is that not correct, Senator Winfield?
Senator Winfield.
Thank you, Madam President. Thank you, Senator Bradley, for the question. You are correct.
Senator Bradley.
Thank you very much. And now you go further, right? And you say in this piece of legislation that you crafted, you say that in general cases there's still qualified immunity. The barrier that you establish is that the people have to meet a certain prong to that. Is that correct, Senator?
Senator Winfield.
Thank you, Madam President. Through you, that would be correct as well.
Senator Bradley.
I'm sorry. I get a little excited. I got to slow down. Maybe I should drink some water or take a breath. I apologize. And the barrier that you put on there is for you to personally be able to sue the police officer, right? Because other than that, if he uses qualified immunity, correct me if I'm wrong, if he uses qualified immunity and they're able to establish that it was, he made a split-second decision, he did it with good cause, there's nothing there that shows that he violated his laws, he could still use that, and the city's on the hook if there's anything to hold the city on the hook for. But the only way a police officer is going to lose his pension and lose his house and lose everything he's worked so hard for how many ever years he was a police officer, if you establish certain things, and those things are willful and wanting conduct. Is that correct?
Senator Winfield.
Thank you, Madam President. Again, Senator Bradley reads the bill correctly.
Words.
Senator Bradley.
And those aren't just words that are words. Those words have meaning. Those are terms of art. And the Black Law Dictionary defined those words. And the Black Law Dictionary, as every jurist here knows, is what we all go to, whether you went to Harvard or you went to wherever. We go to define words. It says acting consciously, disregarding, or acting with reckless indifference to consequences. That's what a person would have to establish in their lawsuit to be able to prevail and sue, particularly this police officer. Isn't that correct?
Senator Winfield.
Yes, thank you again, Madam President. That is correct as well.
So now,
Senator Bradley.
let me understand what you're saying. What we're saying now is that when it comes to that particular issue of suing a police officer, you're saying that that no longer will be a question of law, with what I think Senator Brazzaro was talking about, the summary judgment motion process, right? Where a judge makes a decision as to whether or not the facts are sufficiently clear and the law says that it shouldn't proceed. It will no longer be a question of law in regard to this particular section of the law. Is that correct?
Senator Winfield.
Thank you, Madam President. Sorry, lead. Thank you, Madam President. I would say that Senator Bradley is correct again.
Senator Bradley.
And in those cases, you bring it to a jury. Now, I don't know how many lawyers here have done a jury trial before, but I've done a few of them, and I'll tell you what. I'm usually hard-pressed to impanel minorities on that jury. I'm in Fairfield County. I'm usually hard, and I pass legislation here saying we should never impanel a jury that's all any race, because nobody wants to see an all-black jury, an all-Hispanic jury, an all-white jury. That stinks on its face of discrimination and bias. If I was a white person and I saw an all-black jury impaneled against me, and the victim was a black person, the police officer arrested me was a black person, and the judge is a black person, and the prosecutor's a black person, and my lawyer's a black person, I wouldn't feel like I'm getting a fair shot at the system if that was impaneled against me. I would say there was bias there, right? But in Connecticut, we're saying the only way we're going to move forward is if a jury makes a determination. The jury of our peers, the people that we run to on an everyday basis that we believe, love, and think that cops are doing right by us. That's what we're talking about. Isn't that correct, Senator?
Senator Winfield.
Through you, Madam President, again, the Senator reads the bill correctly.
Senator Bradley.
And I'll tell you something else that's going to shock and get all the people on my side of the aisle all mad at me, as they sometimes do. Let's talk about the police camera situation. We're saying in this piece of legislation, and correct me if I'm wrong, that we're mandating that police officers have these body cameras. Is that correct?
Senator Winfield.
Thank you, Madam President. Yes.
Senator Bradley.
Thank you, Madam President. And at the same time, we're saying we're going to get rid of consent searches. Is that correct?
Senator Winfield.
Thank you, Madam President. Yes.
Senator Bradley.
I take issue with that. I really do. Because I think that if a police officer has somebody on tape who gives a knowledgeable consent of their rights for whatever reason, and there's clearly established evidence that they weren't coerced, that they weren't intimidated, that they weren't pressured because we have them on tape, then we should allow that admission to come into court. And if a cop finds a gun or he finds a knife or he finds the drugs or he finds whatever he has, we don't want bad guys to be on the street on a technicality, just like I wouldn't want to see bad cops get away with murder on a technicality. I wouldn't want this law to go the other way around, where a cop shoots somebody and this great wall of silence comes and they make a phone call and they say, hey, I did this and that, tell them I did this and tell them I was here and tell them I was that, and there's coercion and there's all collusion happening between the police officers, and then the detective who's investigating the shooting says, give me your phone, and he consents to it. He says, sure, here's my phone, and they see these text messages back and forth saying that there was coercion and collusion and all the rest, and they say, well, because you took that, it's fruit of the poisonous tree, you violated its constitutional right, and now we can't use that, so you can't show that the cop had any intent to do any type of criminal action. I would hate for the technicality like that to happen when we know better. But you know what? It's the compromise that we're reaching and its ability to make everybody come together. And we have to swallow these things because it's an imperfect world. But we do it with the love of knowing that our country has to move forward in a positive direction. And I'll say one last thing that I think is important for me to know, and I made 101 notes, and you get up here and you forget usually sometimes what you're talking about, but if you could bear with me here just so I could make sure I'm right on these things. I think that's the essence of what I want to say here on the record on this particular piece of legislation. I brought with me, and I don't do it in any type of disparaging way, an American flag. I love this flag. I love this flag, and I would never, ever pass a piece of legislation that goes to punish police officers with indifference, to punish black people with indifference, to punish anybody with indifference. I love this flag, and I vote for this, knowing that it is not perfect because none of us here are perfect, knowing that it is a compromise because that's what our founding fathers intended us to do, to compromise. And I vote for this applauding the hard work of Senator Winfield, because I know it's been blood, sweat, and tears, and I know it hasn't been easy to come to this compromise, but I believe wholeheartedly this is going to make America better. And what I don't want to see, ever, is that these United States of America no longer exist. Because we have a black America and a white America. And if we think it can't happen, it happens time and time again to many, many civilizations on earth that a minority group feels disenfranchised and rebels against another group. I do not want to see a country where black people and brown people in this country feel that we don't have a stake in this country anymore and we have to go out and fend our own country or find our own way or have division in this country. We had it once before. It was called the Civil War. Other countries have had it before where they've separated and gone their own way. We don't want to see a country that's divided. We have to bring everybody together. And this legislation is exactly that. Not to put cops down, but to protect all citizens of this great free republic. God bless you.
Thank you, Senator Bradley. Will you remark further on the bill that is before us? Good evening.